The decision whether a company should pay dividend is a business one, but once that decision is made, there are some legal aspects to make it so. Today on Zippy Point. I'm Brock Romanak, and I'm a big fan of yous. So a dividend is one method that companies use to distribute earnings to their shareholders, one way to pay return on investment. It's typically in the form of cash, a cash dividend, but it also could be in the form of stock, known as both a stock dividend or a stock split, depending on how you legally set it up. Dividends are always quoted in annual terms, as is the dividend yield, but most companies pay their dividends quarterly, not annually. So when a company says that they pay quarterly dividends, it means that the company pays dividends every quarter. But if the company is saying that it has a $6 dividend, you're not going to receive $6 every quarter. You're going to get $1.50 per share. Whether companies want to pay a dividend typically depends on the industry that they're in. There might be peer pressure in some industries to pay dividends for sure because their peers are doing it. Shareholder activism may be involved. Shareholders may pressure a company in certain industries to begin issuing dividends or to boost the dividend rates, enhance them if they believe it's warranted because there's excess cash on the balance sheet. Of course, a company has to have the financial wherewithal to pull this off. Dividend increases tend to be gradual, and the sudden reduction or downright elimination of dividend payments can dramatically impact a company's stock price. Consistent, increasing dividend payments are a hallmark of a solid, stable business that generates substantial cash flow for those types of investors looking for that kind of return. So let's talk about that legal research before your dividend declaration. Before a company declares a dividend, you're going to have to research state law, the state in which your company is incorporated, and any regulations if you're in a highly regulated industry. Or utilities or banking industries typically have dividend paying companies, and they have regulations for those industries that are specific to those industries. So let's consider some state laws. Section 170 of the Delaware General Corporation Law grants power to the board to declare dividends, subject to any restrictions contained in the company's charter. Section 170 also limits the board's authority by definitions and computations related to surplus and capital. Dividends ordinarily can be paid from a company's surplus or net profits, but state requirements and methods, how you calculate these things, depend on the state you're in. In Delaware, there's case law about how to value a company's assets and liabilities to make that determination about surplus, but the DGCL itself doesn't set forth much guidance. And then you're going to want to check your corporate governance documents, your bylaws, your charter. So here's a sample provision from a set of bylaws about a board's power to declare dividends. It's usually pretty straightforward. And then also you're going to need to check the terms of your indentures, your debt covenants, the terms of your preferred stock issuances. They sometimes limit your authority to declare dividends, perhaps an outright ban, or perhaps a majority of the holders of preferred stock might have to consent to a dividend before it can be declared. Same thing with your debt holders. A stock dividend is simply a dividend payment that's made in the form of additional stock being paid to existing shareholders. Typically, it comes in the form of fractions of the company's common stock. The company may need to distribute stock if it's low on cash, if it's going to declare any dividends at all. And again, you're going to check state law for the computation here, surplus net profits. If you're a Delaware corporation, you're going to look at Section 173 about par value. You're going to look at Section 155 about fractional shares. If there aren't enough authorized and unissued shares or treasury stock available to issue a stock dividend, the company's going to have to consider shareholder approval to amend its charter to increase its number of authorized shares. That's some work. Oh, I hear someone at the door. It's the Cookie. That's my dog, Willa. Say hello, Cookie. She's a cutie. She's a cutie. She doesn't want me to film today, but I'm going to do it anyways. Okay, let's talk about board approval of the issuance. The board needs to act each time it wants to declare a dividend. You can't set it up so it just continues routinely. Each time there's a dividend declaration, the board needs to act to approve it. So your state law and your governance documents will dictate the type of board approval you need. Section 141 of the DGCL provides boards with the power to declare a dividend if by a majority vote, and that's the default standard that can be altered by the company's charter or bylaws. Section 141 also allows the board to delegate the authority to declare a dividend to a board committee. So the board would have to set it up by delegating that authority either by a board resolution or putting that in the bylaws or the charter. Section 172 of the DGCL protects directors generally from liability if they rely in good faith upon the books and records of the company or a report of an independent expert selected with reasonable care about to determine whether the company has sufficient funds. And the company can also probably agree to indemnify a director to a certain extent for an unlawful dividend claim if the board meets a standard of conduct set forth in Section 145 of the DGCL. Each time a board or a board committee, if that's delegated to a committee, declares a dividend, it must do via a board resolution that includes the amount to be paid, the record date for determining which shareholders are entitled to receive payment, the payment date, and authorization for actions and documents necessary to affect the declaration. The board resolution typically uses the terminology that's in the applicable state law to reflect that the board acted with the authority that it has. State law and your governance documents will set forth the parameters for your record date under Section 213C of the DGCL. The record date can't precede the date that the board acts by resolution. To fix the record date, it must be within 60 days, 60 calendar days of the payment date. Once you set the record date, you'll inform your stock exchange and it will set an ex-dividend date that normally is 2 business days before the record date. Ex-dividend means the first day of trading after the dividend is payable. Shares trade without right to the dividend on or after that date. So a shareholder that buys stock on the ex-dividend date or afterwards won't receive the next dividend payment, but a shareholder that buys a stock before the ex-dividend date will receive the payment. So let's talk about exchange notification. Both stock exchanges, the NYSE and NASDAQ, consider dividend announcements to be material information that require public disclosure made promptly. You find that in the NYSE's Section 202.06 and NASDAQ Rule 5250. Section 204.12 of the New York Stock Exchange Listing Company Manual and NASDAQ Listing Rule 5250E6 both require that companies give notice to the exchange of any dividend action at least 10 calendar days in advance of the record date, but both encourage you to inform the exchange as soon as possible after the board acts. And the NYSE specifically encourages the payment date to happen as soon as possible after the record date. And here's their note, a little description of what they think of as accepted practice in this area. For the NYSE, the dividend should be publicly announced as soon as possible after it's authorized by the board. Sometimes that might happen in the middle of a trading day. And regardless of when the announcement is made, whether during or after trading hours, Section 204.12 requires the company to provide a copy of the release to the NYSE at least 10 minutes in advance of issuing it. If the dividend is in any way unusual, the amount materially deviates from the amount regularly paid, a special dividend, then the NYSE might consider halting trading for a brief period pending the dissemination of the news. Under Rule 5250, NASDAQ permits any Reg FD compliant method of disclosure and requires notice as soon as possible after declaration and in any event no later than simultaneous with public disclosure. Material changes in your dividends must also be provided to NASDAQ's MarketWatch through their electronic disclosure submission system. So let's talk about SEC filings. A dividend, even if it's a stock dividend, is not considered a sale under the 33 Act, so they don't require registration with the SEC as noted in this CorpFin staff interpretation. Even so, your transfer agent may request a legal opinion to confirm that the dividend is exempt from registration. Speaking of the 33 Act, the failure to pay dividends on preferred stock is an S3 disqualifying event under General Instruction 1A4 of Form S3. And then in terms of ongoing disclosure, you're going to have disclosure in your Form K. Part 2, Item 5 refers to Item 201 of Regulation SK. And here's an example of what that disclosure looks like in a Form 10K. Now, interestingly enough, Item 201 has this provision that if companies have a record of not paying cash dividends, although their earnings indicate an ability to do so, they are encouraged to consider the question of their intention to pay cash dividends in the foreseeable future. So they're looking for forward-looking disclosure here in Item 201. I'm not sure many people realize that. And then if companies have a history of paying cash dividends, they're encouraged to indicate whether they currently expect that to continue. and if not, the nature of the change in the amount. So this is interesting disclosure that's required in 10Ks pursuant to 201 of SK. Consider it. So let's talk about the financials for a second. The dividends declared and paid by a company in the most fiscal year will show up in these ways in the statement of cash flows. It's going to be use of cash under the financing activities heading. Under the statement of stockholders' equity, it's a subtraction from retained earnings. Dividends that have been declared but not yet paid are going to be reported on the balance sheet under current liabilities. And dividends on common stock are not reported on the income statement in any way since they're not expenses. So given that dividend declarations are considered material news by the NYSE and NASDAQ, companies typically voluntarily file a Form 8K when the board declares a dividend because it's not an 8K triggering event with its own number that's not enumerated. I'm not sure why dividends didn't get their own enumerated item in Form 8K by the SEC, given how universal practice it is to file a Form 8K when you declare a dividend, particularly when you look at some of the other enumerated triggering events. But anyways, some companies furnish the 8K that announce a dividend declaration under Item 701 as a Reg FD disclosure. So this is furnished, not filed. Well, some companies file those 8Ks under Item 8.01 so that the information is officially in the company's SEC reporting streams for purposes of incorporating that 8K by reference into 33 Act registration statements, because again, this is material information typically. The 8Ks typically are one-liners with the press release attached as an exhibit under Item 901. So here's an example of a quarterly cash dividend announcement. And here's a sample 8K for a special dividend. So let's talk about the reduction and suspension of dividends. If a company is having liquidity problems, financial problems, you should be including disclosure that you might have trouble paying your dividend. If you've had a practice of paying a dividend in your MD&A and as a risk factor too, and of course you have that Item 201 disclosure in your 10K that I just mentioned, and of course your accounts are going to be covering this in your financials. And then when the board bites the bullet and takes action to actually cut the dividend, you're going to be filing that information on an 8K, likely under Item 801 and not just 701, to report this big news. This indeed is big news and will likely impact the company's stock price. So you're going to need to treat that information as material non-public information when you're pre-clearing any trades for insiders. You're going to have a blackout period for anyone in the know that knows about the board making the declaration between that period of time and when you're actually issuing a press release announcing a suspension or a cut in the dividends. You want to time those two so they're pretty close together. So here's an example of a Form 8K that announces a dividend suspension. There was a lot of these that happened last year due to COVID. And then here's an example of an 8K for a dividend deferral. What happened here is that the dividend was declared, and then after it was declared, the company realized, oh, we can't really make the payment, so we're going to put that off for now. So it's not just a suspension, it's already been declared, but now the company is saying we're going to have to defer this to another time. And then here's an example of a resumption of a suspended dividend, but at a reduced rate than what the dividend rate was before the suspension. Then also consider whether you have to make disclosure in your Form 10Q for a material arrearage in the payment of dividend under Item 3B of Part 2 of Form 10Q. Material arrearage in the payment of dividends. Honey, and you wonder why I became a lawyer. Ah, man, the plain English sometimes, huh? So I'm going to leave you with a debate over whether companies get a bigger bang for their buck if they announce dividends at the same time when they release their earnings every quarter. Let me know what you think.